there's a lot to cover, so I'm going to go pretty quickly. This PowerPoint was prepared with respect to guardianships and doing a lot of the planning that we're going to be talking about as a way to avoid the guardianship. So, Kari, let's switch. Let's keep going. Okay, so one of the legal documents that you need that everyone should have is a power of attorney. It's not actually an estate document so much as a document to use while you're alive because the power of attorney dies with you. In other words, it does not continue after your death. But in the power of attorney, you can appoint one or more people to help you do certain things. For example, write checks, sign a lease, renew your lease, file your taxes. Let's say you're ill, you're not, and it's April 14th, and it's time to do your taxes. Um, you need some, and you can't sign because you've broken your wrist, for example. A power, the agent that you name under the power of attorney can do that for you. And that's a very useful tool. Let's skip forward. Next, okay. So this all explains what a power of attorney does, and I I've given you a broad brush about what it does. It's a legal form. You can download it from the internet, but I would be very, very, very careful about that because the ones on the internet um, do not provide for things like transferring assets to obtain Medicaid, to do what's called Medicaid planning. Um, and you need to execute the document in certain ways. There's an area where you actually must initial, and if you leave it blank, and I just saw one that was left blank, you're giving no one any power whatsoever. Um, let's skip forward. Okay. So the durable power of attorney means that it will survive any incapacity that you might have. And by the way, when you name an agent, not only do you have to be able to sign the document in front of a notary, but the people you name in the document also, as agent, also has to sign the power of attorney in front of a notary for it to become effective. So if you're not ready to give up power or you're concerned about that, you can sign it but not give it to your agent until it's time that you need it. Okay, let's skip forward. All right. Let's just keep let's just keep going because I think I'm not going to spend a lot of time with powers of attorney, although we are going to talk about trusts and a power, and your agent under the power of attorney can create a trust or join an already created trust. And the powers that you convey in the power of attorney can also, um, if you do it, if you provide certain, if you include certain provisions, will allow your agent to engage in Medicaid planning for you. You want to be able to engage in Medicaid planning so that your assets are preserved and you still get government benefits. Let's skip forward. Okay, let's skip forward. Another important document is a healthcare proxy. A healthcare proxy allows you to name the person you want to make medical decisions for you in the event that you cannot. For example, you're unconscious, you're under general anesthesia, they're giving you so many drugs you can't figure out what they're talking about. Um, you can only name one person at a time. That means that if you've got a son and daughter and you've got to name one of them. You can name them in succession, first my daughter and then my son, but it can't be both because the doctors do not want to have to deal with committees. I'll give you a personal example. I'm my husband's power of attorney, a healthcare agent. However, he is not mine because he doesn't really like to talk to doctors and he just shuts down. Just so happens my closest friend is a nurse, and so she's my healthcare proxy. although of course she would do it in conjunction with speaking with my husband. Um, if you do not sign a healthcare proxy, then the law takes over, and there in New York State there is a uh, medical decision family care medical decision making act, and it outlines that first comes in a court appointed guardian to make your medical decision, then a spouse. If there's no spouse available, a parent. If there's no parent available, a child over the age of 18. But you may, and if there's no child over the age of 18, a sibling, but it doesn't say which sibling, that can be a problem. Some people have heard the term living will. A living will is like a healthcare proxy, but a healthcare proxy is recognized by the courts, so that if the doctors don't do what your healthcare agent is saying, the healthcare agent can go to court. A living will is not recognized by the courts. In a living will, generally you name an agent, but it's more specifically you outline, you do this with a healthcare proxy as well. You outline what you want or don't want. I want to be resuscitated. I don't want to be on a ventilator. I do want artificial nutrition. I want all pain medication. Whatever it is you want or you don't want, you can outline in both a healthcare proxy and in a living will. Next slide. This explains the living will. And as I said, you can include your wants and desires, but it is not enforceable in a court of law. Next slide. Next slide. Okay. Again, you can only name one person at a time to be your healthcare agent. And if you sign a healthcare proxy, which by the way, you can download from New York State, the New York State website, you can has a statutory healthcare proxy form, which you can download. You need 2 witnesses. I don't believe it needs to be notarized. You need to give a copy of your healthcare proxy to your treating doctors for their files, and to your healthcare agent and the successor healthcare agent. And the reason you want to give your healthcare proxy to your treating doctors now, and I don't mean your like podiatrist, I mean, your oncologist or your endocrinologist if you're a diabetic, certainly your GP, your internal medicine doctor, is because if there's a question as to whether you've chosen the right person, or they want to question you about the healthcare proxy for whatever their reasons might be, if you give it to them ahead of time, they have that opportunity. And if they come up, 10 years later and say, is this really what you want? Your agent can say, you had all this opportunity to question my mother, my sister, my brother about this, and you didn't. Now is not the time. Okay, next slide. It's always hard to choose a healthcare agent under a healthcare proxy. It should be someone you trust. It should be someone who can negotiate with doctors and understand what the doctors are saying. And it does not have to be someone who lives in New York City or lives near you. That's why there's long distance telephone calls. I've had people appoint someone in Italy, and they had to deal with the time difference, but that person was a very good and the only person that my client trusted to make healthcare decisions for her. Okay, next slide. When you choose a healthcare agent, you really need to make sure that that healthcare agent, A, knows your wishes and is willing to carry out your wishes. So you have to have that sit down and say, this is what I want. And if you can't agree to carry out my wishes, I will have to choose someone else. Because you don't want someone who's not going to pull the plug if that's what you want, or So you don't want someone who will not continue treatment if that's what you want. So you have to make sure they understand what you want and and that they're willing to carry out those instructions. Next slide. This is a sample healthcare proxy. We really don't have the time to go through it. I don't know if you can download this. This is the one that I've created for my clients. It's not the one that you would get from the state, but they're virtually the same. So let's skip over. I think this takes a couple of slides. Yep. Keep going. Keep going. Okay, keep going. Keep going. And this is a sample living will. Again, we don't really have the opportunity to go through this, and you can also download this, I think, from the state. It's a couple of slides. Just keep going. Okay. Wait, back up. This is a sample of what's called a disposition of remains form. If you do not have a direct relative who is going to claim your body when the time comes, this is an important document. There are some people who have no family, but they've got a friend that they trust to deal with their remains at the time that you pass away, but that friend does not have any legal authority. So this is a form that you can download from the state website that appoints an agent, and that agent can make decisions about burial, about funeral arrangements, about whether you're embalmed or not, and other things. So this is an important form, and I would encourage you all to download it from the state. Next slide, please. Next slide, please. Okay, just keep going. This is just a fill in. Keep going. And this explains the Family Healthcare Decision Making Act that I referenced earlier. And this allows for the appointment of a surrogate to make medical decisions for you in the event that you cannot make those decisions. This isn't for, someone who's broken a leg and, do I get the cast or not? This is when someone is unconscious or unable to make an informed decision. You can skip forward 2 or 3 slides. Okay. The person you appoint as your agent and your healthcare proxy has no financial responsibility. So you do for you, so that if someone says, "Well, I don't want to be responsible because I don't want to be on the hook for your medical bills," that doesn't come into play here. Let's skip forward because I want to get to the estate part. Okay, keep going, keep going. All right, okay, let's keep going. I'm just going to go without these and let's just go with wills and trusts. If you have $1 million or you have $10, you have an estate. Whatever you have in your name, even if it's not actual money, if it's books or clothing, that's still part of an estate. And in order to, when you pass away, that's when someone applies to the surrogates court, which is different than the Supreme Court. They apply to the surrogates court to represent your estate. Now, if there's a will, they take the will to the courthouse, and the will has to be proven that it was executed properly, that certain words were said at the time that the will was executed, etc. And then eventually, if it's a proper will, the court will issue what are called letters testamentary, and then the person who is named in the will as the executor can go to the bank, get a tax ID number for the estate, and gather up all of the assets, and they'll be able to go into the apartment and just dispose of the assets. and they'll be able to, they will have to contact family members. Even if you don't really like your family, they have to be advised that you have passed away and that someone is handling your estate. In the event that you do not have a will, then the state decides where the money, where your assets go. So someone applies to be the administrator of the estate as opposed to the executor. And in the event that there is no one who applies or cannot qualify, because you have to be a citizen, you have to not be a felon, you have to not have declared bankruptcy. There are lots of reasons why someone may not be able to become the estate representative. Every county in New York State, including New York County, has an Office of Public Administrator, and that office will handle the estate. In the event that you do not have a will, first, the money is distributed according to the law, which is if you have a spouse and no children, it goes all to the spouse. If you have a spouse and one child, $50,000 plus one half goes to your spouse and the rest goes to your one child. If you have a spouse and more than one child, it's 1/3 to your spouse and 2/3 divided amongst however many children you have. If you have a child who predeceased, but that child had children, then that child's portion of your estate is divided equally amongst his or her children. So in order for you to make sure that your estate goes where you want it, you need to do a will. And in that will, you name the executor, the person you trust to handle your estate. And you also say what you want done with whatever you have. I want 50% to go to my son and 20% to go into a trust for my disabled daughter. And I want my disabled daughter to get my grandmother's wedding ring. Whatever it is that you want, you can lay out that way. If you want to avoid having to go to probate, one way of doing it is to create a trust. Another way of doing it is to name people on a bank account. So if you have a bank account, almost every bank will allow, or financial institution will allow you to say payable on death to, and you can say all my children or my children living at the time of my death or my grandchildren. And that escapes the estate. It avoids probate, and it's a good way of easily disposing of your assets without involving the court. Now, there are certain kinds of I've been asked to also go over trusts. There are a variety of trusts. There are trusts where you can put your apartment if you own your apartment, and if it's a co-op, you have to get the co-op's permission. But you put it into a trust to avoid collections by certain debtors, by certain creditors, rather. But if you know you have a creditor and you put it in after you've already been served with papers saying we're suing you for lack of payment, that's creditor fraud, and that's not going to work. But if you do it earlier than that, it may avoid any kind of collection by a creditor. There are trusts called special needs trusts, and that would be a trust created for the benefit of a disabled person or a person who is not disabled yet, but may become disabled. So, for example, someone who has Parkinson's, who is fine now, but is going to need assistance in the future, it will allow that person to obtain medical benefits from Medicaid and still have you have to name a trustee. That trustee will be able to supplement. The person needs additional food or additional, a wheelchair, special kind of wheelchair that Medicaid won't pay for, the government won't pay for, then the funds from the trust can be used for that. That's called a special needs trust. And there are other kinds of trusts as well. There's income only trust, where only your income is placed into the trust, not any principal. A principal is like the bank account or the stock. Um, and the again, this is for Medicaid planning purposes. You're only allowed a certain amount of income every month, and your Social Security may be beyond that income level. So if you go into an income only trust, your income can be diverted into that trust and you can still qualify for Medicaid. I see we have, I have no idea what time it is, but I see we have a lot of questions. So do you want me to address the questions first?
Yeah, we could take a break and we could start with a few questions. The first one is, can multiple power of attorneys be signed by different family members?
Every family member can have a power of attorney. And every family member can name anyone they want in that power of attorney. And you can, unlike a healthcare proxy, you can name one or more people as your primary agent, and then you get successor agents. So, for example, you want your son and daughter to be your power of attorney, your agent under the power of attorney, that's fine. And then in the event that daughter can't do it, you can name a successor. However, most banks, let me back up. The law allows you to have as many agents as you want named in that power of attorney as original agents, but most banks will not allow um, allow for more than two people to sign on a check. So you will have to. It's very hard to find. I can't think of one bank that will allow more than two people on a check. It's also, just difficult if, daughter lives in California and son lives in Florida and they both have to sign a check. The FedEx is going to make a fortune.
Okay, the next question says, how can a will be created if family member is unable to sign due to illness?
There are provisions in the law for that. If the person can speak, the person can say, "This is my last will and testament. I'm asking you to witness my making a mark," if they can make a mark, or if not, someone is authorized to make the mark for me. I'm authorizing Jakari to make the mark for me. Um, there are special provisions for that in the law. If the person cannot speak but can nod, yes or no. Questions can be asked, is this your last will and testament? Nodding yes. And all of the other questions that have to be asked at the time of the execution. Are you over the age of 18? Do you read, write, and understand the English language? And if they don't, then the will should be translated both in English and whatever language they do speak. If they can't read, has it been read to you and does it agree with things? Does it comport with what you want? So you don't have to be able to, if the person is blind, there is wording in what's the provision that's called the acknowledgement that says the testator is blind, it has been read to him or her, and he or she has agreed that this is what he or she wants for their last will and testament. So there are ways to do it.
Okay. The next question, can I write my own will or does it have to be approved by the judge or an attorney?
Well, the judge approves it after you're dead. So it doesn't get you, the judge isn't involved. You can create your own will. It does not have to be done by an attorney. There are all sorts of, legal Zoom that you see the commercials. I love those guys because usually those wills don't stand up and I make a fortune. Or I wish I made a fortune. Um, However, you cannot write your will. A handwritten will is only accepted by the court if the person is in military service and on active duty in a war zone. So it has to be typed. It also has to be signed in a very specific way. The You have to have two witnesses who are not named in the will. Those two witnesses have to see you sign it. You have to say, this is my last will and testament. I am over the age of 18. I read, write, and understand the language in which the will has been written. I am not under any disability. I understand what I'm doing. I haven't taken any drugs or alcohol that that impairs my understanding of what I'm doing right now. I am asking you to witness my signature or my execution if you're not signing, as we discussed earlier, and each other's signature. Also, the will must be stapled or otherwise affixed. In my office, I rivet them together, and the staples may not be removed before it's presented to the court for probate. If it's removed, the assumption is that it has been changed, that, someone's fiddled with the papers, fiddled with the um, intent of the testator, and it is very difficult to overcome. Next question.
Okay. How do you know the difference between a will and a trust, and when should one consider using both?
Okay. You should have a will as soon as possible because there are buses that run people over. So, and a will only takes effect when you are dead. A trust takes effect now or when you execute it, and it can continue beyond your lifetime or it can end when you die. So the will takes care of what happens after you're dead. The trust can become effective immediately as soon as it is funded. By funding, if you create a trust and say, for example, I'm putting my co-op in the trust, but you don't actually transfer the title of the co-op out of your name and into the trust, it's not funded. And that's a mistake that happens quite often. So just because you've signed the trust doesn't mean it's effective. You have to sign the trust, and then in the trust document, you list some of the assets you're going to put into the trust. And you have to put those assets into the trust. You have to change the bank account from Emily Ann Klotz to the Emily Ann Klotz Trust.
The next question comes from Rita. Is a lawyer necessary for surrogate court?
No, no. In fact, the surrogate court, there's a surrogate court website, and it will walk you through the steps of how to do it. And in fact, I haven't been on in a couple of years, but there used to be an icon, and it's a little person who goes through each step, and after each step, the little person in the icon is a little closer to the courthouse steps. It's very cute, actually. So no, you do not need an attorney. It can be confusing without an attorney, but you don't need an attorney.
Okay. The next question is anonymous. What are the most common mistakes people make in estate planning?
Well, there are a number. One is not taking into consideration whether someone who's going to be inheriting is um, disabled. Because if they're on government assistance like Medicaid or SSD or other kinds of government benefit programs, and they get an inheritance of, let's say, $20,000, they're kicked off of the government benefits, and they may need those government benefits. So all the money that they would have inherited gets spent taking care of them. Whereas if you had created a trust in your will or a trust ahead of time and funded that trust for that disabled person, then they can continue on government benefits, which is really what you want for your loved one. Another is that they forget they have certain assets, or they don't think of them as assets. They forget they have a car. Um, they forget to name someone in a plan that they intended.
Well, Emily, before we, keep going with the Q&A, you have anything else you want to talk about in regards to the topic, or you want to just continue with?
I'm happy to do the Q&A because I believe there are 10 more questions,
Yeah,
and I think that that's sort of more responsive.
no problem. Next question is, if a person has Medicare and Medicaid and has a bank account, I guess with $5,000 and dies, can Medicaid claim those funds?
Absolutely. If the person is married, the first there's a certain amount that is entitled to go to the spouse. But other than that, yes, Medicaid is allowed to um, collect against your estate in full up to the amount that was in the bank, or I'm sorry, to up to the amount that Medicaid spent on your care. So if you have $100,000 in Medicaid bills, but you've got $10,000 in the bank, you wouldn't have, yeah, $10,000 in the bank. Medicaid can claim that $10,000, which is why you want to put money into trust if you can, because if it's in trust, it's protected.
Okay, the next question is about payable on death form. Where to get the payable on death form from bank?
To go to your bank manager and say that you want to convert the account to a payable on death, or it's also called for the benefit of, but it's payable. That's also payable on death. Um, and they should provide you with that form right away. It's a simple form to make out.
Which types of property cannot be passed through a will, if any?
Co-ops, co-op shares can be left to someone in the will. However, the co-op does not have to accept that person, whomever you left that to, unless they pass the co-op board requirements. What would happen in the event that your whoever inherits your co-op shares um, can't pass the requirements of the co-op, then they'll have to sell the co-op, and the person who the co-op was left to would get the proceeds of the sale. Anything else can be left in by will.
Okay. My dad, with a last will and testament, as well as a declaration of trust, took care of them until they died. Well, I took care of them until they died. In the declaration of trust, they left everything to me. There are three other siblings. Can they claim anything in the apartment?
Okay. So anybody can claim anything under our system. So that's the first thing you have to know. Can your siblings challenge? What they would have to do is challenge the execution of the trust or the execution of the will, depending on what happens, or depending on which it is. And what they would do is say that there was undue influence. But they would have to prove the undue influence, and it is a very high bar. It's very difficult to prove. Um, and they would have to show it was signed at a time where your father or your mother didn't know what he or she was doing, that they were that you had that whoever was inheriting the funds kept um, prevented your parent, the mother or father, from seeing the child, the other siblings, etc. There are ways to challenge it, but it is very difficult. It's, as I said, a high bar.
Mhm. Um, If a lawyer was assigned and not doing their job, can you find another lawyer?
Always.
My sister applied and got a voluntary administrator, but I have my mom's will with me at our home. What should I do now?
So you need to go to surrogate's court in whatever county your mother died in, and that's where the letters testament, that's where the voluntary administration should have originated. And you can go and say, we have found this will, and and now you have to go prove that it's really a proper will. And your sister's letters will be revoked.
Okay. If your relative lives in another state, how can you do the notary?
Every state has a notary, and the notary will say, an out-of-state notary, there are certain wording for an out-of-state notary, but every state has notaries, even even if it's international. It's not a problem because there's something called an apostille that the person can get, and the person goes to the notary in whatever state he or she is living in and signs the will in front of, or signs the power of attorney or whatever needs to be notarized. It's fine. It happens very frequently.
What do you do with a declaration of trust?
What do you do with a declaration of trust? Simply explains what the trust provisions are, and sometimes it also explains the purpose of the trust, or the 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 person, the grantor, that's the person who creates the trust, the grantor's purpose in creating the trust. You should maintain it, but there's nothing to do with it. You don't do anything with it.
Okay, thank you, Emily. The next question is from Barbara. She asks, "Hi, can you explain the Grand Saint Germain Act? You know what that is?"
I have no idea. Sorry.
Yeah. Okay, Barbara, maybe elaborate more on that. How the next question is how to start a trust.
Okay. Well, for a trust, you really have to go to an attorney. That's, I mean, the trusts are rather complicated, and or can be rather complicated. They don't have to be, but they usually are. And you need to go to an attorney and tell the attorney what your purpose in creating the trust is. You want to protect your assets. You want to provide for your children. You want to provide for a parent. Um, and then there are different kinds of trusts, and those should be explained at length to you by the attorney that with whom you consult.
Okay. Um, can a trust save money? Wait, can a trust save money from Medicare or Medicaid?
Medicare doesn't play into this, but a trust can prevent, can protect funds from collection from Medicaid.
Okay, and then the final question that I have is, how do you go about firing the lawyer and getting if the one assigned is not doing their job?
Well, I'm not sure how you got how an attorney is assigned. Usually, you hire your own attorney, but if you have had an attorney assigned for you or to you, and you're not happy with that attorney, the first thing you need to do is tell the attorney why you're not happy. The reason I say that is because the attorney has an obligation under under laws um, the laws controlling attorneys. That is the Code of Professional Responsibility to um, provide appropriate counseling and be responsive to the client. And if the attorney is not being responsive to the client, then and and learns that he or she is not being responsive to the client because of complaints, then that person is that attorney is under an obligation to withdraw him or herself. He or she may have to apply to the court to be relieved, but that happens quite often.
Yeah, so they followed up and said, no, it was the one that the deceased assigned.
Deceased cannot assign if in the will that it says, I want um, Joe Blow to be the attorney who's handling the estate, there's no legal obligation for for the beneficiaries to accept, or the executor to accept, Joe Blow. It's just not. It, that's was done in the old days. I mean, they don't do that anymore. They don't encourage it anymore. But that person can still be removed. And if necessary, you can go to court and tell the judge. You'd have to make a motion in front of a judge to have the attorney relieved, which is done. Um, and the court will then either direct the attorney to be more responsive, or in the alternative, will allow you to retain a different attorney.
Okay. The next question, how do I get pro bono help? I need help, but are of modest means.
Pro bono help would be, it depends on what area. I mean, housing court has some pro bono help. If it's something like you need Medicaid planning, there are various various, well, it's getting to the end of the end of the school year, but there are various law schools who that will provide pro bono help in order to train attorneys or train law students to be attorneys. Um, if it's pro bono help in terms of Medicaid planning, if you're going into a nursing home, very often the nursing home will provide that information for you. Um, it really depends on the kind of pro bono that you're looking for.
Right.
I'm sorry to be less specific. Perhaps that person can email me and I can give them a better answer.
Okay. So we'll give them the contact at the end.
Okay.
The next question is from anonymous attendee. Is there a way to find out if Medicaid has a lien on a client since they are able to confiscate the funds in the bank?
Well, when someone passes away, there's the Medicaid has a tape match of people who have died within the last year, and once a year they cross reference it. Um, Medicaid is pretty good about, once they find out someone's passed away, in terms of in writing a letter saying you owe X a number of dollars, and it's always a lot. Um, it is also possible to negotiate with Medicaid to see if they will take less than the amount owed, and they're pretty good about that.
We don't have any more questions as of yet.
Okay. So I can go into depth further about trust if you'd like, or wills.
Yeah, whichever one you want to jump into.
Okay. So let's talk about trust, because lots of people are interested in trust. Um, as I said, there are a number of different kinds of trust. So one is called the one that a lot of people are interested in is a special needs trust, which is to protect assets that you would be interested in leaving to your child or grandchild, or in the case of an older person who is ill, um, for example, um, husband and wife create a trust, and the trust is for the benefit of the wife. The husband passes away, Um, and rather than, and the wife is going into a nursing home, for example, rather than having all of that money go into be spent in a nursing home, it is possible for a trust to be created in a will that says this is a special needs trust. In the event my wife is going in, I want my estate to go to my wife in trust. In the event she has to go into a nursing home, it this money is to be protected and used for her benefit. So that is one way of ensuring that the assets that you've worked all of your life to create are protected and you can fund from the estate. I'm not sure that that was clear, but I'm hoping it was. Most of my clients have worked hard for their money and they don't want to see it going to a nursing home or a medical facility. What they want to do is make sure it goes to their kids or their grandkids or their spouse so that the spouse isn't left out in the cold. And one way of doing that is to create a testamentary trust. That's what it's called, a testamentary trust, to place everything into this trust, all of the assets into the trust for the benefit of the spouse or the child or the grandchild, and have that money protected. But that's a special, as I said, a special kind of trust called a special needs trust. You can also create trust now, knowing that you may have to go into a nursing home. Dad's been diagnosed, God forbid, with ALS, Lou Gehrig's disease. It's a terrible disease, and he knows he's going to need a nursing home. You can create a trust to protect the assets. The problem is if you create a trust for that specific reason, there's a 5-year look back period, and dad may need the nursing home before the 5 years. That's a problem. That's why you want to try whenever possible to plan ahead, but it's a gamble. You really don't ever know what your medical situation is going to be.
Um,
Any more questions, or should I keep going on some other area?
we got two. I'm still confused about the notary. I'm sorry, the question is, I'm still confused about the notary when a person needing it lives in another state than the relative they want to be on the will.
Okay. Not on the will, on the healthcare proxy. You don't need to have your will notarized. That's not necessary. Just witnessed by 2 witnesses not named in the will. So if, let's say, you're naming someone in the power of attorney as an agent, and that agent lives in Florida, you send the document to Florida. The person takes the document to a notary in Florida, and the notary in Florida will sign the notary, will notarize that person's signature, and then you put the document back in the envelope and send it back to the person in New York. Is that clear?
Yeah, hopefully it is. So we'll hear back from
Okay.
that attendees. The next question is again about the Medicaid. Can you self-report that a deceased person has money in the bank account?
Why? Sorry. I Can you self-report that someone's basically what I think what you're asking is if someone's cheating on Medicaid. But I'm not sure why you would tell Medicaid that someone's got money in the bank. I'm not really clear as to why you would do that. But can you do it? Sure. Medicaid would be happy to find out that there's someone they don't have to pay for or that they can get money from. But in terms of Medicaid, you're allowed to have $31,000 in assets and still qualify for Medicaid. Now, that's only true in New York. Every state is different. In New Jersey, you're allowed to have $2,000 in the bank.
Mhm. Okay.
And everything that I've said today is New York specific. Every state is different. Every state has different trust requirements, notary requirements. Every state is different.
Okay. And it seems like the attendees
Excuse me.
response about the notary, so they understood what you meant. Um,
They did understand what I mean?
yes, they
Good.
said. Next question, how far can Medicaid claim expenses to be reimbursed? I think it's from 55 and up, am I right?
That's correct. So if you were 40 and getting Medicaid, you're not responsible for paying it back until you hit 55. And then if you continue for another 10 years after that, then from 55 to whenever, that's reimbursable.
Okay. Um, hmm. There is 5,000 in the account. This is back to Medicaid.
Yeah.
There's 5,000 in the account, and I do not want Medicaid to come after me for it, and that's why I thought to self-report.
Okay. But you're allowed to have 5,000 in the bank. As I said, you're allowed to have up to $31,000 in the bank. Self-reporting will only get you kicked off of Medicaid, and you don't want that. What you can do is um, change the bank account to payable on death to, and then when you die, you should live and be well. But when you die, if there's anything left of that $5,000 in the bank, it will automatically go to the person you name as the beneficiary of the account.
Mm. Next question is, hi, can you clarify the best way to put co-op into a trust?
Um, the first thing you have to do is find out if your co-op will allow the shares to be placed into a trust. And that depends on your co-op board. It has everything to do with the board and nothing to, more boards are being liberal about it because they understand that it's Medicaid planning purposes or that, for asset protection purposes, may not be Medicaid, but some other asset protection purposes. And once the co-op allows you to place the property, the co-op into a trust, they usually want to, first of all, the co-op board wants to see the trust. They always want to see the trust first. So you show them the trust. If they approve the trust, then you just transfer the title. And usually the co-op board's lawyers will help you do that
Mhm.
for a fee.
The question just came in. If a person is separated from the spouse, does the spouse have any claim to assets by law, or can it be overwritten by a statement in the will?
That's a more difficult question than you might imagine. Um, if the if it's a formal separation that's been ongoing for a while, then they're not entitled to receive anything under intestacy, but if it was left in the will, for example, if you say in the will, and I like to be very careful about this. If you say in the will, I'm leaving my estate to my husband, that's one thing. If you say in the will, I'm leaving my estate to my husband, Joe Blow, that's different. Or if you're leaving the estate to Joe Blow, comma, my husband, that's also different. I know it doesn't seem different, but it is. And what you're trying to avoid, um, you want First of all, if you're getting divorced or you're separated, you should do a new will. You should do a will to make sure that you're excluding that person. And when you do the will, you can say, my husband, Joe Blow, and I are separated and have been separated for however many years you're separated for. And it is my intention to specifically exclude him from my estate because we have not lived together as husband and wife or as spouses for the last number of years. Was that clear? I'm hoping that was clear.
Yeah, so Jean, can you let us know if that was a clear response? And the final question, and we're going to end it here. The person has already died and was on Medicaid and Medicare. I do not want any issues with Medicaid. Has a 5-year look back provision.
The 5-year look back provision has to do with qualifying for Medicaid. It has nothing to do with recoupment by Medicaid. Medicaid has 7 years to make a claim. I think that's right, but I may be wrong about that. But I think it's 7 years. I don't remember off the top of my head. Um, if if they're not claiming anything, I'd be quiet. Like why open a can of worms? Um, but and if they are claiming something, I would contact them and see if you can negotiate a settlement. And as I said, particularly if there's not a lot of money in the estate, there's they sometimes can be very reasonable. And reasonable is a questionable term, but they can be talked to and explain that this person needs the money and there's only $5,000 in the estate, and what can we do about that? And they may be willing to negotiate.
And Jean said yes, she was clear on what you said.
Okay, good. I'm glad.
So yeah, so that would wrap up the Q&A portion. Emily, do you want to touch on one more thing? It's 8 o'clock, but if you want to touch on anything else, you can.
I encourage Chikari. I don't know how this works, but if there's a specific question that someone wants to ask, they can reach out to me, I guess. I'll give you my email address,
Mm-hmm.
which is,
In the chat box.
can you put it in the chat box?
Mhm.
EKLOTZ30W@gmail.com. I can't be overly specific because if I start giving legal advice, then I become your attorney, whether it's official or not. So I can't be overly specific, but I'm happy to answer general questions.
Okay. Um, so with that being said, I want to thank Emily for being here tonight and presenting and answering everyone's questions. The presentation was very informative, and we look forward to continuing partnering with Emily. And we truly appreciate you and your time tonight. And like
Thank you.
I said in the beginning, estate planning is for everyone, no matter your age or situation. So, it's better to do it sooner than later. And if,
Oh, I do want to say one other thing, Jakari. I'm sorry. It just occurred to me. Once you've done a will, it's not written in stone. You can change your will whenever you want. And I've used this example before in my presentations to Palantes. I had a lady named Fanny, and Fanny would come in every Tuesday to change her will. I'm not kidding. Every single Tuesday. If she didn't show up on a Tuesday, we would reach out to her thinking, my God, she died, because she never missed a Tuesday.
mm, yeah,
She had no money, didn't matter. She was leaving like $2 to everybody, but she was changing that will constantly. So don't think once you've done a will, it's written in stone. It is absolutely not.